A very good evening to Honorable Chief Guest and our Honorable Judges and Senior Advocates and my dear sisters and brothers and to every person assembled here. Now I would like to call upon our respected and beloved President of WAA to deliver the welcome address.
A happy evening to all. I welcome Hon'ble Mr.Justice T.Raja to this Cornelia Sorabji lecture series. This is the first function of the series, which is presided by a judge belonging to Madurai district. It's a great pleasure for WAA to have Hon'ble Mr. Justice Raja amongst us. His Lordship is a relief-oriented judge and finds a way to help the bar. I once again welcome Hon'ble Mr. Justice T.Raja to this lecture series. I welcome Hon'ble Mr. Justice V. Pugarendi for this series. I welcome Senior Advocate Mr. M. Ajmal Khan, who accepted to deliver a speech on basic structure of Indian Constitution. A very simple man and a good and efficient lawyer. I never forget his saying in one of his meetings, if I am right in MBHA, that this is a profession that has got 4 stages. Stage 1, no case and no money. Stage 2, less case and less money. Third stage, more case and more money. And fourth stage, no case but still money will flow. The only thing we have to keep in mind is patience. We have to wait in this profession to get money. Of course, stage is not like that of now. Still, shining in the profession also requires time. Brother Ajmal Khan is a person to help in the need of the hour. After becoming a president of WAA, I just made a call to him. Immediately, he sent rupees 25,000 by check. I'm really shocked. I just asked him, and he said, his reply was, "You have become the president. Necessarily, association needs some monetary help. Therefore, I sent that rupees." When we decided to air condition this hall, I called him and sought for a donation. Having had the experience as a president of an association, knowing the difficulty in fundraising, my brother, Mr. Ajmal Khan, immediately sent rupees 75,000. So I have got a great regard for Brother Ajmal Khan. I welcome Mr. Ajmal Khan, Senior Advocate, to this series. I welcome presidents and secretaries and all office bearers of all associations. I welcome Senior Advocate Mrs. Krishnaveni, Mr. Srinivasa Raghavan, and all beloved advocates and my women members of the bar to this August series. I welcome Mrs. Jayendra Patel, Jessie Jeeva Priya, and all others who are, if I am not named, I may not be mistaken for it for want of time. I did not make a mention about the name. I may be pardoned for that. I welcome you all for this August series. Thank you one and all.
Now I would like to call upon our Vice President of WAA to honor our Honorable Chief Guest, Mr. Justice Raja, to accept this memento as a mark of honoring your Lordship. Thank you, Your Lordship. Honorable Chief Guest, to honor our esteemed Senior Advocate, Mr. Ajmal Khan, sir, who is the Speaker of the Day. Thank you, sir, and thank you, Your Lordship. I request our Senior Advocate to give the lecture on the topic of basic structure of the Constitution.
Honorable Mr. Justice T.Raja, Honorable Mr. Justice B. Pugulendi, Sister Anandavalli, President of Women Lawyer Association, Sivasangari, Secretary, Krishnaveni, the Treasurer, my friend Srinivasa Raghavan, Brother Durai Pandian, and my brothers and sisters who gathered here in this Augustus evening. Good evening to you all. At the outset, I thank Sister Anandavalli for having organized this lecture series and asked me to stand before you to deliver a lecture on basic structures of Indian Constitution. This is sheer coincidence. The topic was chosen last month itself. Now, Citizens Amendment Act was passed by both houses of Parliament, which evoked mixed response from the people and tough opposition parties. A number of repetitions came to be filed before the Supreme Court of India, challenging the Citizens Amendment Act on the ground that it offends basic structures of our Constitution. It is at this stage I am before you to deliver lecture on basic structures of Indian Constitution. Our Constitution that commenced its journey on 26 January 1950 with compartment of 395 articles, 22 parts and 8 schedules. Thanks to Article 368 of Constitution of India, which gives power to the Parliament to amend the Constitution of India, the compartment is being bulged. Now we have got 448 articles, 25 parts and 12 schedules. Coming to the basic structure, can anyone tell me the provision under the Constitution of India which speaks of basic structure? No. No provision in the Constitution of India speaks of basic structure. It is the making of judiciary that is necessitated because of tinkering of the Constitution of India by the Parliament for one reason or another. So to preserve the Constitution and to keep the ideals and objectives of the lawmakers in framing the Constitution of India as such, interference from the judiciary was necessitated to invent the doctrine of basic structure, and therefore it is the making of Indian judiciary, the concept of basic structure of the Constitution of India. Once we deal with the basic structure of Indian Constitution, necessarily we should deal with certain provisions in the Constitution of India before that to understand the basic structure in detail. We have got preamble, that is a preface to the Constitution of India. Then Article 13, Clause 2, that is there in Part 3 of the Constitution of India, which all you know, Part 3 speaks of fundamental rights. Then Article 368, which gives power to the Parliament to amend the Constitution of India. Article 372. These are all certain provisions which we should know before we open our mind to the basic and go into the basic structure of our Indian Constitution. The preamble, though it is a preface before opening the statute book of Constitution, one will go through the preamble, preface. And though it is there in the beginning of the Constitution, as a preamble to open the minds of the constitutional makers, the last provision which was drafted by the Constituent Assembly was preamble. after completing the entire exercise of 395 articles, 22 parts and 8 schedules, the last one which was adopted by the Constituent Assembly is preamble. Because after completing the entire exercise, the Constituent Assembly thought fit to sum up what is there in the Constitution, what they wanted to be our Constitution, to govern the people. And therefore, they drafted the preamble at the last time after completing the entire process of drafting of the Constitution of India. The preamble which opens the minds of the lawmakers. What was there in their mind? What is the objective in framing, in drafting the Constitution of India and giving it to ourselves? Even if we interpret any article in the Constitution of India, necessarily we will go to the preamble to understand the object of that provision. And therefore the preamble is necessary. Even Justice Jagmohan Reddy, speaking for himself in Kesavananda Bharati case, preamble, the principles enshrined in the preamble are the basic structures of Indian Constitution. In the Kesavananda Bharati, which I will come later, and each and every judge spoke of the basic structures of the Constitution of India. What are all the basic structures? Justice Jagmohan Reddy said, the principles enshrined in the preamble are the basic structure of the Constitution of India, and therefore necessarily we should go into the preamble to pave the way for basic structure of our Constitution of India. The preamble which reads this: we the people of India, having solemnly resolved to constitute India, that is objective, to constitute India into a sovereign, socialist, secular democratic republic, and to secure all its citizens justice. What is the nature of justice that is contemplated, that is given? Justice, social, economic, political. Then liberty. What is the nature of liberty? Liberty of thought, expression, belief, faith and worship. Then fraternity. Fraternity assuring the dignity of the individual and the unity and the integrity of the nation. These are all the objectives of our Constitution of India that is enshrined in the preamble of the Constitution of India. Though the word socialist, secular and integrity were not there originally when the Constitution was drafted, it was inbuilt according to Supreme Court. The three words, socialist, secular and integrity, unity and integrity of the nation, those three words were ordered under 42nd Amendment during emergency. It is considered as a mini constitution, a lengthiest amendment that was made by Indira Gandhi government during emergency. The object of 42nd Amendment, if you read the object of 42nd Amendment, it is still there. The object says the word socialist, secular and integrity have undergone tremendous pressure in the recent times. Though the three words are inbuilt in the Constitution of India, it became necessary for the Parliament to expressly state in the Constitution itself. And therefore, the amendment is made incorporating these three words, socialist, secular and integrity. And therefore, even under 42nd Amendment, the object of the amendment itself, it was stated by the Parliament that it has undergone severe stress, though it was inbuilt in the Constitution of India. And therefore, though these three words are not there at the time of drafting of the Constitution of India, it is inbuilt, and it was also held by the Supreme Court in Kesavananda Bharati and other case which I will deal with later. And therefore, this is with regard to the preamble, which we are required to understand the basic structure of our Indian Constitution. Then, Article 13, Clause 2. We have got so many parts, as I said. Part 3 deals with fundamental rights. Part 4 deals with directive principles of state policy. Part that speaks of fundamental rights from Article 12 to 35. 36 to 52 speaks of fundamental rights, directive principles of state policy under Part 4. Article 13 says there are two clauses to Article 13 originally. Article 13, Clause 1, which speaks of laws, legislation, which were in force at the time of commencement of the Constitution, which we are not going to deal with Article 13.1. That is not necessary for the purpose of basic structure, just to understand, because in the light of Article 372 says the laws, legislation, which were in force at the time of commencement of the Constitution shall continue to be in force unless it is repealed or amended by the Parliament or the legislature, according to Article 372. And therefore, whatever the laws, we have got so many colonial legislation. We have got Transfer of Property Act 1882, Indian Evidence Act 1872, so many acts, Indian Penal Code 1860, so many legislation which we are following are colonial legislation, pre-constitutional legislation that was enacted by the British Parliament that continue to apply by virtue of Article 372. Unless and otherwise it is repealed by an act of the Parliament. So, Article 13, Clause 1 says, the laws, legislation which were in force at the time of commencement of the Constitution abridges or inconsistent with Part 3 of the Constitution of India. To the extent of that inconsistency, it is void, according to Article 13, Clause 1. So, whatever the laws which were in force prior to the commencement of the Constitution, if it abridges, take away the fundamental right guaranteed under Part 3 of the Constitution of India, to the extent of such inconsistency, those legislation, those provisions will be void, according to Article 13, Clause 1, that is with regard to the pre-constitutional legislation. Then we will come to Article 13, Clause 2, that is more important for the purpose of understanding the basic structure. The wording implied in 13, Clause 2 is the state shall not make either center or the state, it shall not make any law which abridges or take away the right guaranteed under Part 3 of the Constitution of India. If they make such law, then it is void, according to 13, Clause 2. 13, Clause 2. Then, let us come to 368. 368, as it originally stood, there was no express power conferred on the Parliament to amend the Constitution of India originally. It is only under 24th Amendment, it was only the procedure which was contemplated under Article 368 prior to 24th Amendment. The procedure for effecting amendment to the Constitution of India that was contemplated originally as it stood prior to 24th Amendment. It is only in the 24th Amendment express power was conferred on the Parliament to amend the provisions of the Constitution of India. So, Article 368 empowers the Parliament to amend the Constitution of India, provisions of the Constitution of India. So, the question arose whether the Parliament can amend the provisions of any or all the provisions of the Constitution of India, or the power conferred on the Parliament to amend the Constitution of India is limited. Inherently, if it is limited or not. That issue came. Why such issue came was because of the legislation, agrarian legislation passed by various states immediately after first general election in 1950s. To fulfill the promises made by the Congress government, agrarian legislation were passed by various states to give effect to Article 39, to prevent for equitable distribution of wealth and for prevention of concentration of wealth in a few hands. legislations came to be enacted by various states, that is agrarian legislations. Those legislations passed by states have been challenged before various high courts, especially Bihar, Rajasthan, Uttar Pradesh. Rajasthan, Uttar Pradesh, Allahabad High Court and other High Court upheld the legislation. Patna High Court has declared it is ultra vires, which affirmed Article 19(1)(f) of the Constitution of India. You all know, originally right to property is a fundamental right that was guaranteed under Article 19(1)(f) of the Constitution of India. The fundamental right to property was amended, deleted only under 44th Amendment by the then Janata government. And it was made a constitutional right, a statutory right under Article 300A. So the legislation was tested in the light of Article 19(1)(f). Article 19(1)(f) is in Part 3 of the Constitution of India. The agrarian legislation which takes away the land belonging to the jamindars and for distribution of the same to the other people, that was challenged, which affirmed Article 19(1), right to property guaranteed under Part 3 of the Constitution of India, in the light of Article 13, Clause 2, where the state is debarred from making any legislation which takes away or abridges the right guaranteed under Part 3 of the Constitution of India. And therefore, Patna High Court has declared the legislation as unconstitutional, which went to the Supreme Court. In 1951, then Prime Minister of India, Jawaharlal Nehru, introduced First Amendment that necessitated judgment of the High Court. To get over the judgment of the High Court, the First Amendment was made. And thereby, 9th schedule was created. According to the amendment, if any agrarian legislation was passed that was put into 9th schedule, that is immune from judicial review and that is valid. That legislation was challenged before. That legislation was challenged. And in Sangari Prasad case, the Supreme Court has said, Sangari Prasad, where that agrarian legislation which was struck down by the High Court was challenged before the Supreme Court. The Supreme Court has said the legislation is offending Article 19(1)(f). And the amendment made to the Constitution of India, the Parliament has got power to amend the Constitution of India, and the law, the word law, employed in Article 13, Clause 2, does not include constitutional amendment, according to the Supreme Court of India. Once the law enacted by the Parliament by introducing constitutional amendment is not a law within the meaning of Article 13, Clause 2, then Article 13, Clause 2 will not apply. Parliament can amend any law, any provisions of the law. It cannot be tested in the light of Part 3 of the Constitution of India. So in Sangari Prasad case, Supreme Court has said it is not a law within the meaning of Article 13, Clause 2, and therefore the amendment is valid. And 14 years thereafter, another case has come, that is Sajjan Singh versus State of Rajasthan. In Sajjan Singh versus State of Rajasthan, Constitution bench by a majority of 3:2 has also held the Parliament has got power. And the law, as found in Article 13, Clause 2, will not apply to the constitutional amendment. And therefore, Parliament has got power to make amendment to the Constitution of India. Article 13, Clause 2 will not apply. That uphold parliamentary supremacy in line with Sangari Prasad case. But fortunately, two of the judges, dissenting judges, Justice Hidayatullah and Mudolkar, and both of them have expressed concern over the judgment rendered by the Supreme Court in Sangari Prasad case. Especially Justice Mudolkar, he has used the word basic structure, holding that we have got apprehension whether the judgment of this court in Sangari Prasad, if sustained, will affect the basic structure of our Constitution of India, though no argument was advanced as to the basic structure before the Supreme Court of India. And it's an apprehension expressed by two judges, especially Justice Mudolkar, in Sajjan Singh case. But because of the majority of 3:2, the judgment has gone in line with the Sangari Prasad case, holding the parliamentary supremacy over the amendment of the Constitution of India. And thereafter, 11 judges bench in Golaknath case, that was in 1967. In Golaknath case, 17th Amendment was put on challenge. Supreme Court by 6:5, majority of 6:5, has said the judgment rendered by the Supreme Court in Sajjan Singh and Sangari Prasad will no longer be good in law. And the law, as found in Article 13, Clause 2, includes constitutional amendment also. And therefore, if any amendment was made by the Parliament in exercise of powers conferred under Article 368, has to be tested with the touchstone of Article 13, Clause 2 of the Constitution of India and Part 3 of the Constitution of India, according to Supreme Court, by 6:5 in Golaknath case. The Supreme Court has heard, though the Parliament has got power to amend the Constitution of India, there is an inherent limitation in the power of the Parliament to effect amendment to the Constitution of India. That inherent limitation should not encroach upon the fundamental right to freedom guaranteed under Part 3 of the Constitution of India, according to Supreme Court. And therefore, it uphold the rule of law, holding that constitutional amendment is also a law within the meaning of Article 13, Clause 2. That was rendered in Golaknath case. So that gave trouble to the government to amend the Constitution of India, which takes away certain rights guaranteed under Part 3 of the Constitution of India, and therefore, then government has made an amendment. Amendment is 24th Amendment. 24th Amendment, then 25th and 29th Amendment, to the effect that Article 24th Amendment says Article 13, Clause 2 of the Constitution of India will not apply to the amendment made in exercise of power conferred under Article 368 of Constitution of India, according to 24th Amendment. So it is to get over the judgment of Golaknath case. This amendment was made. And 25th Amendment. 25th Amendment, if any laws made by the state to give effect to directive principles of state policy, especially Article 39B and C of the Constitution of India, will not be called in question. That will not be called in question according to 25th Amendment. And Article 14, 19 and 31 will not apply to challenges to those legislation. According to 25th Amendment, if any amendment is made to give effect to Article 39B and C, that is Directive Principles of State Policy, then it cannot be challenged on the ground that it offended Article 14, 19 and 31 of the Constitution of India. And therefore, these amendment, Amendment 24, 25, 29, those amendments were challenged before the Supreme Court of India. That is in Kesavananda Bharati case, famously called Fundamental Rights case. That case was heard by 13 judges. In the judicial history of India, that was the first case which was heard by 13 judges, large number of judges. In Kesavananda Bharati case, though some apprehensions were raised earlier by the judges as to the basic structure, precisely for the first time, that was argued, that was upheld, that was declared by the Supreme Court, that the basic structure of our Constitution of India cannot be altered, abridged, emasculated, destroyed, changed. These are all the wording employed in Kesavananda Bharati case by a majority of 7:6. 7:6. The Supreme Court has held the fundamental rights. Power is available to the Parliament under Article 368. The basic structure of our Indian Constitution. Basic structure cannot be destroyed, emasculated, changed, altered, abridged. According to Supreme Court, that doctrine was, that concept of basic structure was introduced by the Supreme Court in Kesavananda Bharati case. Then what is the basic structure? Basic structure is the brainchild of the judges. According to me, one concept as inherent in the Constitution of India may be basic structure. But according to my friend Srinivasa Raghavan, it may be another concept that can be the basic structure. Still, the courts have not evolved precisely what are all the basic structures of our Constitution. It goes on interpreting and goes on giving different interpretation and a different concept as basic structure of our Indian Constitution. In Kesavananda Bharati, though by a majority of 7:6, it was held that basic structure cannot be altered. Judges have given separate judgment and evolving certain features of our Constitution as the basic structure of our Indian Constitution. I want to share with you some of the basic features, basic structures which the judges have spoken of in Kesavananda Bharati case. Justice Sikri, the Chief Justice who presided over the 13 judges bench, has said the basic structures are supremacy of the Constitution, republican and a democratic form of government, secular character of the Constitution. Stopping for a moment, this judgment of Kesavananda Bharati was delivered on 24th April 1973. On 24 April 1973, 42nd Amendment was not brought in force. 42nd Amendment was made only in 1975 during emergency, only after Kesavananda Bharati case. And even before, the word secular was incorporated in the preamble of the Constitution of India. In Kesavananda Bharati case, 13 judges have said secularism, secular character of the institution, secular character of the Constitution is a basic structure. That is why in the 42nd Amendment in the objective they said, though it was inbuilt and it has undergone a tremendous stress and therefore it necessitated the government to incorporate expressly the word secularism into the Constitution of India. And therefore the Supreme Court in 1973 has said, secular character of the Constitution is a basic structure. Then separation of powers between the legislature, executive and judiciary is a basic structure. Then federal character of the Constitution is the basic structure. Then Justice Shalat and Grover, they ordered two more features as basic structure of the Constitution, which are the mandate to build a welfare state contained in the directive principles of state policy is a basic structure. Then unity and integrity of the nation is a basic structure according to Justice Shalat and Grover. Then Justice Hegde and Mukherjee, they identified a few basic structures. They are sovereignty of India, democratic character of the polity, unity of the country, essential features of the individual freedoms secured to the citizens, mandate to build a welfare state. These are all the basic structures according to Justice Hegde and Mukherjee. Then Justice Jagmohan Reddy, preamble is the basic structures. The principles enshrined in the preamble of the Constitution of India are basic structures. Then sovereign democratic republic is the basic structure. Then parliamentary democracy is the basic structure. Then three organs of the state, executive, legislature and judiciary, are the basic structure according to him. However, it was not accepted by minority view. That judgment was by Justice A.N. Ray, Justice Beg, Matthew and Divivedi. All of them have said Parliament has got power to make fundamental changes to the Constitution of India and there was no bar for amending for the provisions of the Constitution of India, even the fundamental changes. Fortunately, Justice Khanna, actually earlier it was only 6:6 in Kesavananda Bharati case. It was only Justice Khanna, he has given his 7th judgment, leaning towards fundamental rights, holding that basic structure cannot be amended. And therefore his 7th judgment has helped the majority to hold a view in favor of the citizens' fundamental rights. So this is with regard to Kesavananda Bharati. Though the Kesavananda Bharati judgment was rendered in 1973, various attempts have been made to get over the judgment of Kesavananda Bharati. Even the 3 judges who rendered their judgment in favor of citizens were superseded and their juniors have been made Chief Justice, including Justice A.N. Ray, Beg. They were elevated as Chief Justice because of this judgment rendered in Kesavananda Bharati case. Within 2 years of passing of this judgment, Kesavananda Bharati, in the board, that is in the cost list, case appeared as if for review of Kesavananda Bharati case in the Supreme Court. No one has filed any review petition. No party has filed any review petition. However, it appears for review in the Supreme Court when Justice A.N. Ray was the Chief Justice of India. Among the 13 judges who delivered the judgment, 5 of them were there and the rest of them have retired. And fortunately, by the able argument of Nani Palkiwala. That attempt was thwarted. Once it appeared in the Supreme Court, after 2 years, Nani Palkiwala stood up in the court and said, what, my lord, no one has filed a review petition, but it appears as if for review of Kesavananda Bharati case. Justice A.N. Ray said, and most of the parties wanted to review the judgment and they wanted clarifications. Nani Palkiwala has said, none of us have asked for any clarification. None of us have filed any review petitions. We would not take risk to get over the judgment of Kesavananda Bharati, which held in favor of citizens' fundamental rights. And immediately Justice A.N. Ray said, even Tamil Nadu government has asked for review of the judgment. Fortunately, an able and fearless Advocate General was there. He is none other than Govind Swaminathan. We have seen him, we are fortunate to see him, see his arguments in Madras High Court. And he immediately stood up and said, we have ever and never asked for review of this judgment, my lord. He said, immediately he stood up and said, and Chief Justice A.N. Rai was embraced. And he said, some of the parties have sought for clarification, even the state has sought for clarification of this judgment. And it went on for some time. Nani Palkiwala has not allowed the bench to get over the order passed by the Supreme Court in Kesavananda Bharati case and said, absolutely, it is unwarranted either to ask for clarification or review of the order passed by the Supreme Court. And thereafter it was adjourned. And all the counsels were ready. Thereafter, when the matter was taken up for hearing to face the bench, immediately the case was called. Justice A.N. Ray said, the case was dissolved. This is how an attempt to review the order passed by the Supreme Court in Kesavananda Bharati case was thwarted by the bar, a valiant bar. And thereafter, it was in 1975, and thereafter emergency has come. 42nd Amendment was introduced. 42nd Amendment, though it has got some good provisions, there are provisions which takes away fundamental rights of citizens also. That is the lengthiest amendment which we have ever had. And we also call it as a mini constitution. 42nd Amendment. Under 42nd Amendment, Article 368 was amended. Clause 4 and Clause 5 was inserted to Article 368. Clause 4 and Clause 5 speaks of, Clause 4 says, Article 13, Clause 2 will not apply to the amendment made under Article 368. So, the validity of the amendment can be challenged only in the light of Article 13, Clause 2. As I said, 13, Clause 2 says, if the state shall not make any law which is in derogation or abrogation of rights guaranteed under Part 3 of the Constitution of India. Once Article 368 Clause 4 says, Article 13 Clause 2 will not apply to the amendment made under Article 368, then it cannot be challenged in the light of Part 3 of the Constitution of India. That is Clause 4. And Clause 5, there is no limitation for the Parliament to amend the provisions of the Constitution of India. Without any limitation, it's an inherent power conferred on the Parliament to amend any provisions of the Constitution of India without any limitation. under class 5. So those provisions, those amendment was challenged before the Supreme Court. In Minerva Mills case, that was challenged. The Supreme Court has said, judicial review is the basic structure of the Constitution of India. The power available to the judiciary cannot be taken away. Under the amendment, if any legislation was passed and it was kept in the 9th schedule under Article 31C, then it is immune from challenge to the court. The court shall have no power to go into the validity or otherwise of the powers available to the Parliament in introducing the legislation. And therefore, the Supreme Court has held the amendment, 42nd Amendment, which takes away the rights of the courts, jurisdiction of the court to decide the validity of the legislation affirmed the basic structure of the Constitution of India. So the judicial review is also the basic structure of the Constitution of India. Not only here and thereafter, in number of judgments you see. Judgments in the sense, in L. Chandrakumar case. L. Chandrakumar, an advocate from Madras bar. Earlier, a tribunal was created. As against the order passed by the tribunal, an appeal will lie only before the Supreme Court of India, and the High Court has no power. Article 323B was challenged before the Supreme Court of India, where the Supreme Court has held High Court in exercise of powers conferred under Article 226 and 227 have got jurisdiction to decide the order passed by the tribunals. And therefore, judicial review is the basic structure of the Indian Constitution, according to Supreme Court in L. Chandrakumar case. Even thereafter now, 124, Article 124A, which introduced the NJAC, National Judicial Appointment Commission, that was challenged before the Supreme Court of India by Supreme Court Advocates on Record Association, wherein the Supreme Court has said judicial review is the basic structure of Indian Constitution. So in Minerva Mill case, that 42nd Amendment, insofar as which takes away the power of the court to go into the validity of the legislation, was struck down by the Supreme Court of India, holding that it is the basic structure of the Constitution of India. And thereafter, in Rajnarayanan case, Indira Gandhi versus Rajnarayanan case, 39th Amendment was introduced by the then Prime Minister Indira Gandhi. That was introduced at a time when the Allahabad High Court set aside the election of Indira Gandhi, then Prime Minister of India, against which appeal was filed before the Supreme Court. The vacation judge, Justice Krishna Iyer, entertained the appeal and he granted conditional stay. Stay of the judgment on condition that she should not vote, she should not draw salary and all. So, pending that petition, pending that appeal, 39th Amendment was introduced by Congress government. Under 39th Amendment, the election of Prime Minister, President, Vice President, and the Speaker of India cannot be challenged in the court of law. And if any challenge was made pending amendment, that will become abated according to 39th Amendment, so that she can get over the pronouncement of orders by the Supreme Court of India in the challenge made against her election. That was challenged before the Supreme Court of India in Rajnarayanan case, Indira Nehru Gandhi versus Rajnarayanan. The Supreme Court has struck down that article concerned article is Article 329 capital A of the Constitution. That was inserted by 39th Amendment. That was struck down. And thereafter, in Nagaraj case, the Supreme Court has, that is reported in 2006, 8 SEC page 2, 2012, The Supreme Court has coined the concept of twin test to understand the basic structure of the Constitution of India. The twin test are with test, WIDTH, with test, identity test, with test and identity test. With test in the sense, even if the Constitution is enlarged, bulged, it should not affect the basic structure of the Constitution of India. Then the identity test, if any amendment is made, by virtue of that amendment, the identity of our Constitution is lost, then it offends basic structure of the Constitution of India, according to Nagaraj case. Earlier, when I speak of the Constitution of India, I said I compared Constitution with a journey in a train. By amending the provisions of the Constitution of India, the structure of the train is changed into a bus. Then that identity is lost. Once that identity is lost, it offends the basic structure of our Constitution. And therefore, it is the duty of the court to preserve the identity of our Constitution. That is why various features have been declared by the Supreme Court as basic structure of our Constitution of India, including secularism. Then I.R. Coelho, 9 judges bench, that agrarian legislation that has come from Tamil Nadu, that Gudalur land reform law, I think, that was challenged in the Supreme Court, where the Supreme Court has held there is no unlimited power to destroy the fundamental rights of the Constitution. There is no unlimited power to destroy the fundamental rights of the Constitution, and the Supreme Court has said basic features are something which has got some overreaching principles. There are certain overreaching principles which are fundamental to the governance of our country. Those overreaching principles are the basic structures of our Indian Constitution. And recently in Ayodhya case, Supreme Court has declared secularism as the basic structure of our Indian Constitution. Likewise, each and every day, the concept of basic structure is increasing. And the present Citizens Amendment Act has to be tested in the light of these judgments, which I have made it clear what are all the basic structures of our Constitution. Now the Citizens Amendment Act was passed. In the Citizens Amendment, in the Act, some community and certain groups have been excluded. There is a clause legislation in this Citizens Amendment Act, and therefore it is opposed by the opposition parties. Whether it offends basic structure of the Constitution of India or not, it is left to you to decide. And further, matter is sub judice, but we all know, we are all learned people. We understand what is the basic feature of the Constitution of India, how our Constitution has been built in, and how we are running the government and the society, and we know what are the basic structure, whether it will stand to the scrutiny of law or remain to be seen. And that is why I said I left to you. And going by the present happenings, I can tell you one thing, take it from me. Though 13 judges have said basic structure cannot be amended, there is no unlimited power available to the Parliament to amend the Constitution of India. A day will come soon for the Constitution of more than 13 judges to get over the judgment of Supreme Court in Kesavanandi Bharati case. You can expect the same to happen in near future shortly. And we will see whether the Supreme Court will stand to the test of time and they will uphold rule of law and favor the fundamental rights of citizens or protect the government. We will see in future. Thank you for. Thank you.
We are all known. Our esteemed senior advocate is one of the role model to most of the advocates as well as budding advocates who are practicing here. Our esteemed senior advocate has given most valuable lecture about the topic of basic structure of the Constitution by enumerating various landmark judgments. Thank you, sir, for this opportunity to hear your lectures, Lordship. Now I request our Honorable Chief Guest to deliver a special address.
Good evening to all of you. I'm just carrying more paper than Mr. Rajmal Khan. It is not to frighten you, but to recollect some of the important notes which I have made it in the last few days. My esteemed Brother Justice Polendi, Mr. Ajmal Khan, Senior Advocate, was able to explain what is basic structure of the Indian Constitution to all of you. Ms. Anandavalli, President of the Women Advocates Association, Madurai Bench, Ms. Sivasankari, Secretary, Office Bearers, learned members of the bar, distinguished members of various bar associations who have come here to hear the speech given by our Ajmal Khan Senior Counsel. I am indeed delighted to be here to preside over this lecture series in the name of Cornelia Surabji, whom I consider as one of the courageous and adventurous lawyer India and Britain have ever seen till now. This Cornelia Surabji was the first Indian lawyer and also the first Britain lawyer, born and became woman lawyer in Britain, the Great Britain. In fact, I must compliment and congratulate the Women Advocate Association, Office Bearers, for having organized a lecture series in the name of Cornelia Surabji to inform you and other people that everyone, more particularly the lawyer, practicing from lower court till the apex court, should have the basic qualities, namely courage, ability to present cases with all clarity. A lawyer may be a very able lawyer, having blessed with eloquence, clarity, and the intellectual ability to understand the cases told by your client to be presented before the court. But if a lawyer fails to possess the basic, the fundamental, the first quality, namely the courage, you may not be a successful lawyer. I can tell you several interesting cases, but due to the constraint of time, I can tell you only small example. Somebody comes, in fact, myself and Brother Justice Polendi, every day we are facing with the Gundas Act. People are all booked under Gundas, passed by the district collector. When the district collector passes an order branding somebody as Gunda for various reasons, and you are very next door neighbor, lawyer of this district collector, you should have the courage to take up the case. If you think that no, he is my next door neighbor, collector, tomorrow I may not be able to go to him, I may not be able to pass through his premises, then you will be a failure in your life. You should have the basic courage to represent cases, good cases, before any court, either before the High Court, Supreme Court, District Court, even before the quasi-judicial authority. In that way, I find this Hon'ble Sorabji is a very, very immutable lawyer. We have to imitate from her. The first qualification a lawyer one has to possess, namely the courage. When she wanted to study law, she was applying for some scholarship, but then it was very surprisingly refused. You know, the reason on which it was refused was because she was a lady, woman lawyer, woman. So the scholarship to pursue the higher studies, namely the law, was refused on the ground that the person was a lady. Finally, it was refused. She went to her friends, and ultimately some of the organization came forward to meet the expenditure to complete the law. Ultimately, she pursued the law, taking the assistance from the organization, and became lawyer, first lawyer in India and also the first lawyer in Great Britain. So to commemorate, to remember such a courageous person, our Women Advocate Association has organized this lecture series in the name of Hon'ble Sorabji. Really, it is a very good and a welcome step. You must continue to do that. So I once again compliment. Friends, today we have heard wonderful speech given by Mr. Ajmal Khan on the basic structure of Indian Constitution. Very nicely he has prepared. And I must say that all lawyers practicing in our High Court could have been present today, but they missed it. Very dry subject, but very nicely has simplified it. I congratulate Mr. Ajmal Khan. Very nice. Now, as a matter of fact, Ms. Anandavalli also told me, you have to come and proceed over. But I also prepared something. So let me also give you only some brief notes, because it is very much essential for the young lawyers. Now let us split this topic, basic structure of the Indian Constitution, into two topics. Basic structure, one, and then Constitution, Indian Constitution. I will go to the Indian Constitution, because as a lawyer, you must understand what is the Constitution. It is a sine qua non for a lawyer to know what is Constitution, what is law, what is an act. Constitution is a parent act under which any law which is going to be made by the states, we have 33 states in our country. Union territories are all there. 25 high courts we have. Every state can legislate in their state assembly. They can legislate any number of acts in the larger interest. But we must bear it in mind that every law, each legislation that is going to be enacted by all the states, including the parliament, should go in line with the constitutional provisions. If they are not going in line with the constitutional provision, that will be considered as invalid or considered as unconstitutional, and that can be struck down. That is what Mr. Ajmal Khan was explaining, if a state legislature is making a law that should fall in line with the provision subclass 2 of Article 13, what is law? Very interesting thing you must understand, you must know. In 1950, I'm sorry, I can still go one step further. We got independence, 15th August 1947. Immediately, we have enacted this Constitution of India. We have adopted the Constitution of India on 26 November 1949. We must remember that. Within 2 months, the Constitution has come into force with effect from 26 January 1950. Some of the provisions, Article 6, 7, 8, 9, 10, 324, etc., were given effect from the date on which we adopted the Constitution, namely on 26 November 1949. But the major portion of the Constitution of India were given effect, were brought into force with effect from 26 January 1950. Therefore, we celebrate this Constitution Day on 26 January every year, declared as a holiday. Look at the importance the country has given it. Sorry, 26 November we are celebrating, but 26 January, the Republic Day. So the 26 January is considered as very, very important special day for us, because we have to remember the Constitution. So 26 November is a day on which we have adopted. 26 January, some portion of the very important salient features of the Constitution has been brought into force. Therefore, we celebrate this 26 January as a Republic Day. So India became Republic. The moment the Constitution came into force, 2 acts, namely the Government of India Act 1935 was repealed, and then Indians Independence Act 1947, that was also repealed. The Government of India Act was really working in lieu of this Constitution, Indian Constitution. That was also given a go-by. Now, as a student of law, what is the need for Constitution? This background one has to know. The very basis, the very purpose, the very motto for which the Constitution of India was enacted and that has been brought into force with effect from 26 January 1950 and some provisions from 26 November 1949 is for one reason. We got independence. Sardar Vallabhbhai Patel, Dr. Rajendra Prasad, Nehru, Gandhi, all important, Menon, Krishna Menon. And you must know the background of the Krishna Menon. He was fighting for India in UN. One day, Jawaharlal Nehru, former Prime Minister, late Prime Minister, he was just asking the Krishna Menon, Mr. Krishna Menon, why don't you go slow? Because I am not able to follow your speech. He was so fast, so genius. These are all the people, because he was very openly telling Mr. Krishna Menon, who was representing India in the UN, if you are speaking like this, then I may not be able to follow even one line of your argument, one line of your presentation. Please go so slow. And that was the greatness of these people who are all responsible for enacting this Constitution. They have joined together, sat together. They were just discussing what is the need for enacting this Constitution. The first reason was, prior to India's independence, just see the great kingdom of Mysore that was ruled by Tipu Sultan, who was a secularistic leader, a secularistic ruler. His father, Hyder Ali, was in fact helping many, many kings who were ruling here and there in Tamil Nadu. After the Hyder Ali passed away, Tipu Sultan came to rule the Mysore kingdom, joining hands with this Nizam of Hyderabad, with this British force, and also taking support from the Marathan rulers. These all three forces went and attacked Mysore kingdom. And then finally they killed Tipu Sultan. That scenario was joyfully enjoyed by the Thiruvangur Maharaja. He was not able to intervene because they were not able to see, although the British forces are all coming, though having small limited number, they could have intervened, stopped this killing of this, Tipu Sultan. They could have saved the Mysore kingdom from being annihilated, from being defeated. But they were keeping quiet. This Nizam of Hyderabad, taking support from this Marathan king, and also taking guidance from this British forces, after attacking this Mysore kingdom, they have come to Tamil Nadu and also taking the support of this Arcot Nawab. They went to Ramanathapuram. They invaded Ramanathapuram, imprisoned all the king's family, and then they went to Panjalangurichi. They were demanding this tax. Tax is not very important item, but tax every princely state person who is running a princely state should pay some tax to the British forces as a mark of subjugation to them. When this Veerapandi Kattaboman refused, saying that I will not pay this tax to you because you are not giving any consideration to me, Panjalangurichi was attacked, we all know that. And then Veerapandi Kattaboman was captured and he was hanged to death. Then his brother Umathurai came running to Sivagangai. Marudhu brothers, they gave asylum, shelter to him. For the reason that this Umathurai, the brother of Veerapandi Kattaboman, was given asylum in Sivagangai, they invaded Sivagangai, killed this king. The first queen was also killed. The second queen, one Rani, Velu Nachiyar, she ran to Tindikkal and then she was taking shelter somewhere else. They were looking at all these things. When all these fights were all going, Panjalangurichi was attacked repeatedly, Veerapandi Kattaboman was hanged, and then whosoever was helping Veerapandi Kattaboman were also done to death, and they were all imprisoned. This Pudukkottai Maharaja was keeping quiet. He was just siding with British forces. He was not able to intervene. They have considered, then these are all the things taking place in South India. If we just go to the Pondicherry, Pondicherry completely was occupied by the French forces now. So India, look at it, British force taking support from our own kings, they are attacking, creating problem. Ultimately, they captured the entire dominion of India, subjugated the India. To recover from these forces, we had to fight for 200 years. Ultimately, after 200 years, after sacrificing so many valuable, so many lives, we were able to attain India's independence on 15th August 1947. Realizing these things, the first question they discussed was how to manage ourselves. In those days, from Tamil Nadu, people may not be able to trade with people in Calcutta. From Mumbai, people will not be able to trade with a man who is living in Mysore or Karnataka. The reason is because there is no any common highways. There may be roads, but it is not properly maintained. The reason is, in Tamil Nadu we have seen Sera Pandiyars, and then the Nayakar family, and then Veerapandi Kattaboman one side, Ramanathapuram one side, Sivagangai one side. There is no coordination. They don't bother. So they wanted to just unify the India so that in future at least nobody will be able to come and attack and then subjugate us and make us slaves. That is a reason why, that is a big purpose, big idea on which they thought, yes, we have to have one law. That law is the Constitution of India. What is the purpose of Constitution of India? You must appreciate one thing. Today, Honorable Prime Minister is there. His Excellency, the President, is there. When they thought that there must be one executive, namely the President of India, after unifying the entire state, one man should be there as a president, and he should be given with executive power. After this president, there must be another person, namely the Prime Minister. Look at the ideas, look at the visionary of these people. We must realize this. How this Prime Minister has been brought in, how the President has been brought in, how the Chief Minister has been brought in. They all worked out all these ideas, and they said, the Constitution will give limited power. The Constitution will give assigned work. See, we have the Honorable Prime Minister. Can you and I go and tell him, Honorable Prime Minister, this is your duties. Have you done it? But if you see Article 78 of the Constitution of India, it says, look, Honorable Prime Minister, you are supposed to go and meet the President of India. Whatever is happening before the cabinet, you must go and report to the President. You must go and report. Article 78 gives the power, gives the duties. I am not saying the power. Power is there. But the Constitution enumerates the duties. I cannot tell you the duties. You cannot tell me the duties. But if the Constitution says, you and anybody else, any layman, any lawman can question. In case for any reason, if Honorable A fails to discharge the duties, the Constitution tells, yes, you are entitled to question that. For example, I am just giving a small illustration. Prime Minister is there. Forget about our country. For example, Tamil Nadu. That also not good an example. I will give you another example now. There is one country. One country is having a Prime Minister, President. But that Prime Minister is not reporting to the President. Parliament is meeting. Proceedings are taking place in the Parliament. For 2 years, 3 years, 4 years, he is not even meeting and reporting to the President. Citizen of this country can just come and ask for the explanation. Why you are not briefed the President? The reason being, the President alone is responsible to the people. He will address the nation saying that this is the law the government is going to bring in. And this is the law we are going to repeal it because this is not good for the country. So therefore the Prime Minister, after taking part in the cabinet meeting, will have to go and brief the Prime Minister of India, President, and the President will deliver, will make known what is happening in the Parliament to the public. That is the ideology on which this Article 78 has been framed, giving the duties to the Prime Minister of India. Similarly, if you see Article 52, there shall be a President of India. It says, Article 52, there shall be a President of India. If somebody wants, you will have 2-3 Prime Minister, 2-3 President of India. There may not be consistency. Therefore, anticipating some problem, the Constitution has envisaged only one President of India, one Vice President. Why that Vice President? If you see the duties and functions of the Vice President, it goes very clearly. In the event of the President not able to discharge his duties, then the Vice President will go into the steps of the President of India. So all these duties, powers, functions have been properly enumerated now. This is the case when the Constitution gives the duties to the Prime Minister. It also gives duties to the citizen of India under Article 51A of the Constitution. Article 51A says, every citizen in our country shall respect the nation, the national anthem, national flag. It goes on like this. You have to preserve the harmony. You have to promote the harmony and fraternity among all the citizens. And if you come to Article 14, the 14 says, the state shall not deny to any person equality before law or equal protection of law. Today, in fact, Mr. Ajmal Khan was mentioning that the Citizenship Act bill, the CAP, has come and created so much of problem. Article 14 says, the state shall not deny equality before law or equal protection of law. So if a person has become citizen, then he is entitled to get equal protection of law and equality before law. That means it goes in many plurality meaning now. It goes with several meanings now. So these are all the special features our forefathers have framed for the betterment of the country. Ultimately, these powers, these functions, these responsibilities have been assigned to all the people. And the Constitution has created three organs. What you call these executives, legislatures, and the judiciary. And then also it says, after giving the highest the guarantees. What are the highest guarantees? If you see Article 19(1) A to G, all citizens shall have the right to freedom of speech and expression. All the citizens shall have the right to form a union. All the citizens shall have the right to move freely throughout the territory of India. All the citizens shall have the right to reside in any parts of the India. So these are all the things by which of these basic the fundamental rights guaranteed under Article 19(1) from A to G, a person who is living in Tamil Nadu can go to Calcutta, he can set up a shop, he can purchase a star hotel, or he can purchase 5-star hotel, or he can set up a factory, he can set up an industry. A person who is in Karnataka, he can come to Tamil Nadu, he can set up a factory, because article guarantees. This is what the constitution makers have thought of ultimately for the purpose of unity, integrity of the nation. This constitution has been made. Now the constitution has come in. Let us not unnecessarily go into the other details. I will just now, this is the constitution. The constitution is made for the sole purpose that the people living in different states should stand united, so that we will be getting enough strength in the event of somebody from other side, some foreigner like British force is coming and attacking, then we will be able to stand together and then we can repel the force now. For that purpose, they thought that once again India should not fall prey to any kind of foreigners. They have united now, united the country. This is the purpose. This is the constitution has come in now. The second aspect is, what is the basic feature of the Constitution of India? The basic feature, more than 1 hour, Mr. Ajmal Khan has explained. The theory as a student of law, but I do not want to go into the issues and the speech made by Mr. Ajmal Khan. Now from the point of view of lawyer, you must appreciate one thing, and it is very, very essential. From, 1950, I mentioned 26 January 1950, some very important articles of the Constitution have come into force. The judgment of the Supreme Court in Kesavananda Bharati, that was delivered in 1973, you look at the difference, 23 years, 1950, and then the Kesavananda Bharati judgment was in 1973. Between these two events, 23 years have gone by. Please understand one thing, nobody was able to understand, nobody was able to appreciate what is that basic structure. What was basic structure? For the first time, Supreme Court in 1973 in the holy Kesavaran the Bharati case has invented what he called the basic structure of the Constitution of India. And then one another very interesting aspect is, in fact, as a student of law, you must understand, you must appreciate that even Supreme Court also has fallen in great error in not following, not appreciating what is the basic structure theory now. In fact, Ajmal Khan also has mentioned, in 1950, when the first amendment was tested in the Sangari Prasad case, look at how the interpretation came from the bench. In fact, I must appreciate, right interpretation has come from the bar, but it was not rightly, from the right perspective, it was not taken up. In Sangari Prasad, they argued two things. State means parliament. Law means even the amendment. But Sangari Prasad said, law does not fall. The amendment that the parliament is going to make cannot be brought under the purview of Article 13, subclass 2. There is a very serious, serious narrow view. And then, ultimately, then once again, after 14 years, when they questioned that when some of the states were making laws, fixing the land holdings, that the one zamindar who is having hundreds of acres or 200 of acres or thousands of acres cannot be allowed to have thousands of acres of lands. And then each family should have only 50 acres of lands. That person came and challenged it, the Sajjan Singh, in the state of in the state of Rajasthan. When he questioned, see, the Constitution gives us the basic fundamental rights, namely right to own property, but you are taking away your my right that is guaranteed under Article 19(1) A to G, that is F. It is also there under Part 3. And then Article 13(2) says, if any state is making any law which is contravening the provisions of the Constitution, will be considered as a invalid law. It shall be held as unconstitutional. You are just interfering with my property that has been guaranteed under Article 19(1). Therefore, any law which is taking away my right which has been guaranteed under Part 3, that not be allowed to take place. Then again, after 14 years, Supreme Court in Sajjan Singh's case versus State of Tamil Nadu, they reiterated the same view of this Sangari Prasad. Ultimately, again, when the Punjab state government, Punjab state brought in another legislation abolishing the zamindars, fixing the land holdings, a family can have only 50 acres of lands. Again, that Sangari Prasad, that Kolaknath, he challenged the correctness of validity of the act now. When he challenged the validity of the act, now I am just coming to the point of view of the lawyer now. In Sangari Prasad in the year 1950, court said, law or the amendment which is made by the parliament exercising the power conferred under Article 368 does not fall under subclass 2 of Article 13. But Sangari Prasad, in Kolaknath, in 1967, completely reversed the view taken by the Supreme Court in Sangari Prasad in 1950. Again, the another view taken, the same view that was reiterated in the year 65. That is within 14 years. They reiterated the same view of the Sangari Prasad in this Sajjan Singh's case. Supreme Court in IC Kolaknath with the ratio of 60:5, 11 judges bench, they reversed the views of these two judgments, and they said, no, the parliament has no power by exercising the power conferred under Article 368 of the Constitution, giving power to the Parliament to make law, to amend, to carry out any amendment, you cannot destroy the basic feature, you cannot take away the fundamental rights guaranteed under Article 19(1) from A to G. Now the question is, look at it how the court is taking views. These are all going to indicate that a lawyer, one idea which is coming in the mind of a lawyer can change the constitution, can change the entire nation. And the telling example I can tell you, this is what had happened in the Kolaknath case. When Kolaknath said, from the date of judgment given by the Supreme Court in the year 1967, look, Parliament, you do not have a power to destroy the basic feature, destroy the fundamental rights guaranteed under this Part 3, namely under Article 19(1). From the date of the judgment, please do not make any more amendment. You do not have the power. The reason is, the power given to the Parliament through Article 368 is only limited power. And you are rightly mentioned, through this limited power, you cannot destroy the entire power of the Constitution. The power, the Constitution is a very huge one. The supremacy of the Constitution cannot be destroyed by using the limited power given under Article 368. Now, the Parliament is functioning only on the basis of the power which is given under Article 368. 368 is the only area where the Parliament is able to function. If the Parliament is running the show, transacting the business, means it is only because of Article 368. That Kolaknath has made it clear, see, the limited power is given to you, but you cannot destroy the entire thing. Therefore, you do not have any power. From the date, look at the clarity of the Supreme Court in Kolaknath. It says, from the date on which the judgment has come into force, look, do not make any amendment that would destroy the fundamental rights guaranteed to the citizens of India under Article 14, under Article 19, and then Article 21, etc., etc. Now, to get over this problem, what happened then? They wanted to repeal the judgment of this Supreme Court in Kolaknath. When the 24th Amendment, 26th Amendment, 25th Amendment, 29th Amendments were all brought in, here is a case. Again, a lawyer has to be, keep vigil over your right. I do not know how far it is going to reach you. The point is, how one single individual's idea is saving the nation, saving an individual to the greater extent now. This man, this Kesavananda Bharati, is a priest belonging to one Hindu mutt living in Kerala. This man knows Mr. Nani Palgiwala. Kerala government has enacted a legislation fixing the holdings. A family cannot have more than this much acres of lands. This holy Kesavananda Bharati was thinking a while. After thinking for a while, he thought that he must come to Bombay and meet Nani Palgiwala. He came to Palgiwala. He was discussing with Palgiwala. Look at the case of this Palgiwala now. Nani Palgiwala, if I were in his place, to be more frank with you, I would have said, Mr. Kesavananda Bharati, Sangari Prasad is there against you. The Sajjan Singh's case is also there after 14 years by Supreme Court is against you. And then Kolaknath was in your favor in 1967, but unfortunately the Parliament has overruled the Kolaknath judgment. Therefore, please back off. Go back to your Kerala. Save the money. Do not make any attempt. Look at this great Nani. Nani said, Sangari Prasad was rightly overruled. Sajjan Singh was also rightly overruled. And the Kolaknath has come to your rescue. But the Parliament has wrongly brought in what you call the amendment, 24th Amendment, 25th Amendment, 26th Amendment, and 29th Amendment. But we do not find any justification for this amendment. Therefore, do not go back to your High Court, Kerala High Court. But the Kerala High Court may not be able to entertain your writ petition. Look at the lawyer's advice. We will go to Supreme Court. We will tell the Supreme Court, look, the judgment given by the Supreme Court in Sangari Prasad is wrong. Because Kolaknath, you yourself has mentioned that these two judgments are wrong. But unfortunately, the Parliament has brought in this 24th Amendment. The sanctity of the court proceedings have been given complete go-by. That cannot take place. The reason being, if you allow this 24th Amendment today to repeal your judgment, every day you will be passing order, and every week they will be passing an Amendment Act. Then the sanctity of your holding, your proceeding inside the court hall will go waste. That has awakened the judges of the Supreme Court. Ultimately, they thought that the matter should be taken up. Writ petition filed directly under Article 32 was taken on file. And then it is really a hilarious message and very stupendous job. We must appreciate the Supreme Court. Supreme Court said, yes, 11 bench judgment in Kolaknath was repealed. We will go for constituting 13 benches, 13 judges. A larger bench was constituted. We today consider this Kesavananda Bharati judgment is a holy judgment. If you go to the other people, if you discuss with the other people, the learned members of the bar, they will first say, this Kesavananda Bharati judgment has preserved the democracy of this nation. The democracy of the nation has been protected by this Kesavananda Bharati through the great man Nani Palkiwala. Nani Palkiwala has united the nation, preserved the sovereignty of the nation, the integrity of the nation has been preserved, the independence of judiciary has been preserved, and then the secularism has been preserved. Look how one individual's mind has stood the test of the time, and I expect that every one of you should at least imitate the idea of Mr. Nani Palkiwala. Friends, fortunately he was able to convince the Supreme Court, and the Supreme Court said, yes, Mr. Nani, you are right. And ultimately, they are very careful. They were not little careless like in Kolaknath judgment. They wanted to be very careful. And they said, we will lay down what is the basic features. They said, Parliament may again create one more onslaught on the judiciary. By virtue of this judgment given by the Supreme Court in this Kesavananda Bharati, you see, it is a lesson to the judiciary, it is a lesson to the other world, other nations. The democracy of this country has been saved. And they said, look, you have the power. You can make amendment. But do not make any venture to damage the basic feature of the Constitution. The basic feature of the Indian Constitution, they have laid down. What are these basic features? Well, they do not want to be careless. They want to be very, very careful. And they said, look, if you are making any law that is going to damage the unity, integrity, sovereignty of the India, then that law, that amendment will have to go back in the same way. You cannot make any amendment, number one. Then they also said, democratic character. The democratic character of the nation can never be damaged. Today, we have seen that. For example, the next government comes back with all 500 MP seats. They can rewrite the Constitution, but the law laid down by the Supreme Court says you cannot rewrite the Constitution. You can rewrite, but you leave alone these basic features, namely the unity, integrity, democracy, secularism, etc., etc. And the the separation of powers. All these areas are untouchables. You cannot just interfere with these salient features of the Constitution. You do your work, but leave these areas untouched. This is how the Kesavananda Bharati has gifted to all of us. And today, in fact, I do not want to take more time. It is, although it is very interesting, I know you are all lawyers, you must go back to your chambers in your office, your clients will be waiting to give you more material instruction also. So I do not want to stand in between, but I will rest with this saying that be as a lawyer like Nani Palgivala. If you are a lawyer, see, you think twice, you think thrice, you think any number of times in the positive way. See how your idea can be accepted. You have to, for that, you have to self-educate yourself. Every day you have to read. Every day you have to read the Constitution. Every day you have to read some article, some judgment. Maybe today the Land Acquisition Act. Tomorrow some criminal judgment coming from the criminal side. You have to read it. You must self-educate. There is none in this country to guide you properly, but you have to self-educate yourself. And for that purpose, you are having wonderful libraries now. In library, all the books are all there, all the judgments are there. And you must be thankful enough for these members of the Women Advocate Association. They have given you wonderful library. This type of libraries were not there in those days. When we were all practicing, we used to go to only the library which are all in dilapidated conditions. You have AC, you have wonderful chairs, you have a dining room, you have a restroom. Every provision is made available at your disposal. These are all for your goodness. These are all for your the brilliant future. Therefore, I request all of you, think twice, self-educate yourself, and try to imitate a good lawyer like Govinda Swaminathan, like Nani Palgivala, like K.K. Venugopal, like Parasaran. So with all these things, I rest. I thank you so much. Rest my speech. I thank you so much for having given me an opportunity to share some of my views on this topic. Thank you.
Thank you, Your Lordship, for sharing about the historical moment from the colonial period to till in relating to constitutional changes. And also thank you for Your Lordship for sharing about the current scenario of the Constitution. Now I request our General Secretary of WIA to propose vote of thanks.
Hon'ble Mr. Justice T.Raja, Hon'ble Mr. Justice B. Pugalendi, the Speaker of the Day, Senior Advocate Mr. M. Ajmal Khan sir, the President and Secretaries of all the association, Ms. N. Krishnaveni ma'am, and my senior Srinivas Raghavan sir, members of the bar, women advocates, and my dear friends. Good evening to all. I am privileged to propose thank you note on behalf of WAA. Showing gratitude is one of the simplest yet most powerful thing human can do for each other. With this note, I extend my sincere gratitude to the Honorable Mr. Justice T.Raja for your Lordship's nutshell on the Indian Constitution, how it enacted and how it evolved along with the Indian history and the purpose of enacting the Indian Constitution, Lordship, and necessary qualities an lawyer should have. And your Lordship's every word tells how your Lordship adored the Indian Constitution. And thank you, Lordship. Thank you, Judge, for explaining the purpose of self-educating a lawyer. Thank you, Judge. I extend my thank you note to the Honorable Mr. Justice B. Pugalendi for honoring WAA by your presence. Thank you, Judge. I extend my thanks from the bottom of my heart to the Senior Advocate, Mr. M. Ajmal Khan sir, for an extensive, fascinating coverage of the topic basic structure of the Indian Constitution and up to the current scenario by provoking us to apply the basic structure to the current scenario. So thank you, sir. I remember a couplet here. Thiranarindhu solluga sollai aranum porulum adani nongiyil. Meaning is that கேட்பவரது மனப்பான்மையை அறிந்தே எந்த சொல்லையும் சொல்ல வேண்டும். அப்படி சொல்வதை விட மேலான அறமும் பொருளும் யாதும் இல்லை. This is an apt couplet for our profession. And it may not be wrong if I say the senior advocate Mr. Ajmal Khan sir is the role model for this couplet for the sake of his court drafting. And we thank you sir for sharing your valuable time with us. And I extend my thanks to the President Ms. N. Krishnaveni ma'am, Secretary Ilongo sir, and the President of MBHA Mr. Durai Pandian sir, and the Secretary Mr. Mahendra Badi sir. And I extend my thanks to all the office bearers of the association for your presence and support to WAA. And I extend my thank you note to my senior Mr. Srinivasa Raghavan sir for honoring us by your presence sir. Thank you sir. And I extend my thanks to the office bearers of WAA for their cooperation in the activities of the association. And I extend my thanks to the staffs of WAA. And I extend my thanks to my beloved women advocates and the other advocates and senior advocates who are present here. And I extend my thanks to the MC of the day, Ms. Karthika, for a presentation of the day. And I thank the press and media and thank you one and all. And now everyone is filled with words. In the lighter sense, now I request all of you to join us the high tea. Thank you.